I'm Christine Oldhouse from Surety Title, and welcome everyone today. I'm going to make a couple of introductions here with two of our very experienced title people. Deb Steinlin, you may know, is the manager at Atlantic Shore Title, and will probably be doing most, if not all, of your closings. And Don Spencer is our senior title examiner, and he manages the title production area for our company in producing the actual product, which our product is the title insurance commitment. And both Don and Debbie have extensive title insurance. I won't say how much because they look much younger than they really are. Extensive title experience. All of us combined have probably been 130 years of title experience between us. So we've been doing this for a long time. The point of the session that we're going to have today, and we're going to try to fit two more in over the coming months before year end, is not to teach you how to clear title, because that's our expertise, but how to partner with you so that the process goes along in the pace that it needs to go, and that things run smoothly, and we all get to that finish line, which is the closing, because no one in this room gets paid if it doesn't close. So we thought maybe it would be a good idea to have a few sessions on how we can better communicate, maybe tell you what the title process is. Very often we are asked, can you get maybe something prevented you from ordering the title. Sometimes the question will come up, I have a rush deal, can you get this title done in 2 days because we want to close in 3 days? We can always help you with something when you have a problem like that. But can you close in 3 days is a whole nother thing. It's kind of like taking a pregnancy test and asking for the results before they're back. We don't know until the title search is back and we've reviewed it if there's something that may prevent us from closing, because it's going to take clearance time and a lot of work. And there are certain title issues that can come up in a title search which can take a month to cure. They don't happen all that often, but it does happen. So we thought we'd come up with some tips on what could help us from the very beginning, from getting us a fully signed agreement of sale that is very clear, that the names are entered on your contract of sale properly, because very often we get nicknames for buyers on the search and then things have to be redone because the mortgage company is going to put the person's proper name and initial. Little tips like this that can really save time, save a day, save hours in the process, and can help Debbie and her team to cure the title. Once the search is done at the county, we can get that done very quickly, but then it comes back and it goes to our production department, and Don Spencer and his team, they need to analyze all of the information, because we order numerous searches. We order searches in the county, we order them at the municipality, and we order them in the upper courts of the state of New Jersey. And then everything comes back to us in bits and pieces, and it has to be reviewed and analyzed and sorted out to see if it affects our property. Sometimes there is a deceased seller, so a whole estate enters into it. There may be partnerships, and we have to review the agreement. There's a lot of different moving parts that come into title. It seems, I know, kind of maybe simple on the closing end by the time you get there, but there are a lot of things that come into play. Don analyzes all of the information that comes in. He puts together that picture, which is the title insurance commitment. Today he's going to briefly go over the most important parts of that title commitment, not for you to analyze, but so that you can know, particularly if you have, you have a buyer or a seller, but if you are on the listing end, you want to see what your seller has that is clouding or affecting the title that may need to be cleared. You want to know that up front so that we can begin to work on that with your seller. In addition, Don will comply with all of the lender requirements, because if the purchaser is getting a mortgage, they like specific language, and so it's good for us to know up front who the lender is, who are we going to be working with. Very often the lender's not known at the time of the contract to sale is signed, and commitments go out, and then it has to be redone with all of the lender information in it. So we thought maybe these tips could help us work together in our partnership to make this process a lot smoother, and to help each other understand, what are the roadblocks and when things come up that maybe we can work together on. After the title commitment goes out, it moves to Deb Steinling's office and her department, and then they begin to cure the title, working with the seller. Let's find out account numbers to get mortgage payoffs. Maybe there's an old mortgage on there that was never, it was paid off, it was never removed of a record. So we have to go through a whole process to find out how to cure that. An estate perhaps, and we have to, find out whether proper papers filed. Let's take a look at them. Who has the right to sign and sell this property? Riparian issues, which is another complicated area. So they will work to begin that process of curing the title and communicating with you so that we can ensure a smooth and a timely closing. So first up, Don Spencer.
Okay, in your packet you should all have a copy of the title report. It looks like this. If you don't have one, there's a couple extra folders up here that you might grab and use it. Okay, before I begin, I think, just like Christine had said, the important thing is to really get the most accurate information you can get from your sellers or buyers, because that eliminates the reason to have to keep doing revisions on the title, and it just slows up the whole process. And a lot of times you can even push your sellers or buyers, because a lot of times they don't even really know the information if it's coming to an estate, or they don't really know who, they just assume somebody is the owner and they tell you to put them on the contracts. But so it's just important to really get the most accurate information you can get, because that helps us all get to the settlement table a lot quicker. Okay, on the front of the title commitment, which is the first page, this contains a lot of information. At the very top, it has Atlantic Shore's titles, name. It has the file number, which in this case is 2046AS-1. If there's a loan number from the lender, they want it on there, so that would be the 2011 number. And then the property address that's being sold, that's also listed at the top. We have, I think, 5 or 6 different underwriters, so depending on which one we're using, on this one, for the example I use, it's WFG National Title Insurance Company. It could be any one of 4 or 5 different companies that is our underwriter that we use. So then we move down to the actual information that concerns what's going to be handled at the settlement. The commitment date, which in this particular case, this is just an example, I just kind of fudged up, put some fake name in there and stuff. The commitment date is the date that the county's covering when we actually get the title search back, which in this case it was January 8th, 2018. It's usually about a week behind the actual current date, because they have to index all the names and mortgages and different things, so they're about a week behind. Some counties are up to a month, depending on where you are, but Atlantic County's pretty good. They're usually within a week or so. So that's number one. Number two, these are the policies that we're going to issue, which is primarily either the owner's policy, and if they're getting financing, it'll be a loan policy too. So in this case, it shows the name of the insured, which is going to be Larry Smith. He's the purchaser. The sale price is $168,000. He's going to be getting a mortgage with Finance of America Mortgage LLC, and the mortgage amount is going to be $164,957 even. A lot of times we'll get applications in that they're not quite sure of the lender. So if we don't know who it is, we'll just put "to be advised" in there, just so we can get the title work out. And again, most accurate information you can get, that really is important. It just, again, speeds up the whole process. Number three, this is when someone's buying a house, it's in fee simple. Sometimes if we're going to insure a leasehold estate, it'll say leasehold or fee simple, which means they're actually going to buy the property in that fashion. Number four, this tells how the seller got title to the property. In this case, the person who's selling it got it from Secretary of HUD, and it gives the date of the deed recorded, the book page, and the instrument number. A lot of the lenders require us to do a 24-month chain of title, which means if there's been numerous sales within 24 months, we have to list all of those deeds. So sometimes you can have 2 or 3 deeds, and if there's even been estates, it can be pretty lengthy. So the one on the top is the one that shows how, the last book and page where the seller actually got title. Does anybody have any questions on the front page?
Can I see what it looks like?
Oh, we have extra copies here.
Did you get a folder?
Okay, that's what I thought I was.
It's missing the sign.
Oh, okay.
It may be in the front folder.
Right, I said, I'm trying to figure out where he saw it.
It's in the folder. What was the time frame
I'm gonna
that
make some copies.
There may
ownership?
be some in here, some in the front,
The
in the
lender's
front
required to
row.
have a 24-month chain of
Oh,
title.
okay.
24 months?
Yeah, because they want to see who's owned it within the last 2 years.
Yeah.
So in this case, the person
That's why I was
owned
like,
it
no,
since 2003, so clearly
I'm
it's,
trying to follow.
so they only expect to see
Yeah, there's some in the
there's
front.
any reference in there.
Cars.
Any other questions? Okay, if we move to page 2, this is the actual legal description of the property that's being sold. You can have all kinds of descriptions on property. Some can be, 3 courses or 10 courses if it's a big piece of property with a lot of acreage. But usually this is the description that we find in the last deed of record. We put it in the title report. We make sure it matches up with the tax block and lot and the address. A lot of times when we get a survey, and the lender requires a survey, or if the buyer wants to get a new survey, we look at this and compare it with the new survey and make sure it matches it. If there's any problems, then we have to get in touch with the surveyor and find out, where the discrepancy's coming from. But most of the time, they're pretty close. So again, review the survey and make sure it matches. And in this particular description, there's 5 courses, which you can see. It starts with the beginning course, and then it goes around the property, the perimeter, and it takes 5 courses for it to actually close. If it's part of a development, a lot of times it'll reference it underneath the description. This one is saying, being known as Lot 11.20 and Block 14B on the final map of Heritage Commons, which is the name of the development. And that's pretty much it for the legal descriptions. Anyone have any questions on that? Yes?
Yes, I do. So what do you do in the situations where there's encroachments or there's like somebody else's stuff is on the property?
Okay, well, we review the survey once it comes in and issue a survey endorsement. And whatever that shows, we will reflect on the survey endorsement. If there's encroachments, or sometimes there'll be a trailer or a shed that's over the line, or a driveway that meanders into the neighbor's property, or fences that aren't on line, we make reference to whatever is shown on the survey. A lot of times we can't tell whose it is, like the fences, you don't know if the neighbor put it up in the wrong place. And very seldom do you see them being right on the line, because I think even by zoning, you're supposed to be 6 inches inside the line or something like that. But, so it's not real common to see them right on the line. So, but again, it's hard to tell whose is whose, because everybody's connecting into the fences in a development. If everybody has one, if they already have one up, you just connect into it.
John, can you address a little bit about what that means to the buyer? Because we're not saying we're covering that encroachment in the title insurance.
Yeah, we're bringing it to their attention, is basically what the survey endorsement is. It's telling you what issues, if any, there could be. And
So
then it's up-
potentially it should be discussed with the
Yeah,
parties.
it should be discussed between either the buyer's agent or the seller's agent, or if they have an attorney, if it's something that they think is significant. Sometimes you'll have sheds that are over the line, and if it's, a pretty significant amount of footage, you might wanna, have it moved before they actually settle the property, or, or if there's driveways, or, there's sometimes railroad ties that are being built over the property. There's all kinds of things that we've seen, but the main thing that's really a problem is if there's an encroachment, or if there's title overlaps, which is shown on the survey, and then that's something that really needs to, be gotten into with the buyer and seller, and probably get an attorney involved too. Any other questions on the legal descriptions? Yes.
Right now I have a house for sale, which is a corner lot.
Mhm.
And it's off the property, the whole fence, it's like 3 sides of it, off property line and shed as well. But house already went through the CO inspection, and they did the very big survey on it, and city signed on it, they said it's okay, even though it's like, it's a lot. It's a lot.
Yeah, if there's
of
any
land.
kind of encroachment, it really should be referenced on the survey. Why, if it's on a corner
It's
lot?
referenced, it's
Oh, okay,
referenced
yes.
on the survey,
Yeah.
yes. It's as-built survey, so it's referenced,
Oh, okay,
so. But city was okay about it.
I'm sorry.
Because city was okay about it. City didn't say that it's a problem.
Okay, well, that's why when you get a new survey, the buyer orders a new survey, that's certified to them and to the title company. And then that way, if there's a problem down the road, you're basically insured for it if it's something that's not shown by the surveyor. So it's, like you said, it was on the corner and the
It's
fences,
a corner lot.
and the
yeah.
fences were like out past the line.
Yes.
You see, I don't really think that's a problem because it's out into the street bed, it's not into somebody else's property.
Absolutely not.
Yeah, so that's really not, it's just more of a problem if it's
And
on
we
the
checked
street.
with the city and,
Yeah,
they
the
said
city,
it's
I
fine.
mean, unless somebody complains, they probably
They
are.
said as long, they only care that it's not on the sidewalk. Once it's on the
Right.
sidewalk, then there is a problem.
Mhm.
If it's not on the sidewalk, they said it's not a big problem.
Right.
But all the buyers who know about this, they're kind of afraid of it.
Mhm.
The buyers don't like the idea, even though this fence was on the property for like 40
Yeah.
years.
Yeah, well, again, it's really their preference. You know, if they're really concerned, they probably should consult an attorney to really set their mind at ease if they think it's something that's really possibly something that's gonna come back to be a problem later on. But most of the time, if the fences are only off the line a little bit, it's very common. We see that almost on every transaction.
I think one of the things that Don mentioned earlier is a lot of times we do see where a buyer wants to save money and they don't get a survey. And we've seen many problems come up after closing because of the buyer maybe wanted to save the $300 or $400, but if you don't have a new survey drawn and certified to your name as the buyer, you know, you're taking subject to whatever potential issues there are. Your title insurance does not cover encroachments. You know, we can only point them out.
Yeah, because if the survey is made to someone else, the surveyor's only gonna stand behind or their work to that person, not to someone else who, a lot of times they'll bring in surveys to the new buyer and say, here, you can use this. And sometimes we will take it, but a lot of times, again, the surveyor's not gonna back up his work if it's not to the person who's actually buying the property. Okay, any other questions?
Don, are there any townships in this area that require a survey upon transfer of a property? Because I know there's some that they really want a survey done on a new purchase if it's within 4 years because things change. Trees grow over the line, et cetera.
I've never heard of that. I know you need a survey if you wanna put like a deck up, or, you know, if you're
Sure.
doing improvements to your property, they wanna see a survey that's within so many years, so they can, you know, if they're gonna approve it. I know for those situations, but I'm not sure they actually require it on the sale. At least that-
Okay,
that I
so it would
haven't
only be
heard
for
of.
improvements then,
Yeah.
all right. Thank you.
Okay, all right, let's move on to Schedule B, Section 1, which is the next page. On Schedule B, Section 1, this is the area that shows all of the issues that have to be resolved before we can, you know, close or give clear title to the buyer. Sections 1 through 4 on here are pretty much just basic. They're on every one of the commitments. It just says, you know, if something's changed, parties need to let us know. They have to pay the amount of the insurance that's due and owing and pay the premiums. And number 4 is they have to produce the correct documents for us to insure the title, which is basically just the deed, or if there's a lender involved, it's a deed and a mortgage. So this is where we call for the deed and the mortgage. And what this is when there is a deed call, we put in whoever owns the property, we're looking for them to sign on the deed to the buyer. So in some cases, you could have 10 people, or in this case, it's only 1. If it's a primary residence, and the people are living there and they only bought it in their own name and they're married now, the spouse will have to sign off. So there is some different situations where you have to call for other people to sign the deed. But as I said, in this case, you can also see that we'll put in here, and spouse if any. If we're not sure, but that way we get them to tell us if they're married, if they since gotten married since they bought the property. And in that case, if it is the marital residence, they will have to sign. If we're also going to be insuring a mortgage, we call for the buyer to make a mortgage to the lender, and we put in the name that the lender wants us to put in the name. Some of them have like long names and different things, but this one is pretty simple. It's just Finance America Mortgage LLC. So 5, 6, 7, 8, and 9, these are all just other things that we require when we're doing the closing. Need proof of the identity, just proof of their marriage, and all the parties in the transaction have to be disclosed. We require payment of the taxes, charges if there's an association, any kind of fees that are owed. We make sure that the seller's paid up to date so the buyer has clear title from when they take possession. We also do, as Christina mentioned, we do a Superior Court judgment search against the buyers. Anything the judgments are good for 20 years, and they also affect after acquired property. So if you have a buyer that bought a property, say, last year, but they had a judgment from back in 2008, when they go to either mortgage or sell the property, it's going to have to be dealt with. So just because you bought it on a certain date doesn't mean that judgments are only effective from that date forward. They go back 20 years, which would now be back to 1998, 2018. So we do searches on the buyers and the sellers. Some lenders request that we don't do it because if it's a purchase money mortgage, the lender can always foreclose on the judgment and get it wiped out. But if it's a refinance, that's a different situation. So we do judgment searches against the buyers pretty regularly unless we're requested not to. And then we also require an affidavit of title to be signed by whoever owns the property. Anybody who is in title has to sign the affidavit of title that has a bunch of information on there to protect the title company and the buyer, and in case they are not being truthful, that we have a recourse against them if they kind of perjure themselves.
And that would be done at closing.
Yes, yep. Continuing on to number 10, we file a notice of settlement. Basically, this gives the whole world notice that there's a transaction going on. As soon as we do the title report, we actually produce a notice of settlement that shows the buyer, the seller, and if there's a lender involved. They're good for 60 days, so if the transaction is over 60 days, we have to refile it again. Sometimes we refile them 3, sometimes 4 times if it takes a while to get to the closing table. Again, now any kind of liens on the property that we pick up in our search are going to be shown on Schedule B, Section 1. In this particular case, the seller did have a mortgage, so we put it on here. We're going to have to get a payoff from the lender to make sure that we can get that mortgage discharged and that the buyer will have clear title. Number 12, the seller had gotten some solar panels, so they show up sometimes either as a financing statement or they'll put them on as an easement kind of agreement with the solar company. In either case, we have to deal with it because once it's on record, that will jump ahead of the new mortgage if they if for some reason they stop making the payments. So without trying to confuse you too much, that's why we make sure that we get them paid off. If the new buyer wants to continue with the solar company, they can strike a new agreement and they'll file new paperwork, at closing or afterwards.
What happens if the current owner, the seller of this property, and the buyer doesn't want the solar panels? They usually have a lease contract. How do we deal with that?
Well, they have to go back to the company and either have them removed before closing or work out some kind of deal. Because if they take possession and they're still up, that kind of makes it a little sticky situation, because the solar company's still going to expect to get paid. And also it depends too, because I think some of them may be like a binding agreement for so many years, so it really depends on the paperwork because there's a lot of different solar companies.
Yeah, and then on top of it, the roof is ruined, the roof itself, so I don't think you're even able to remove them, because then you would have to replace the roof.
Yeah, it can do damage to the roof once they.
No, they drill the holes.
Yeah.
So.
Yeah, well, if they remove them, they're gonna be, significant damage.
They'll leave the brackets up. They'll take the panels, but they'll leave the brackets.
Oh my God.
I know it's silly, but that's what
Yeah.
they'll do. That's what
Yeah, so it
they'll do.
really depends on the solar company, but that's something you really wanna make sure is taken care of before, we get to closing. In this particular property, there is an association which has monthly fees, so we will contact the association. Our processors will make sure that the fees are paid. If they're not, they will collect them at closing to make sure they're current, and then the new buyers will have to pick up the tab from that point going forward. Is there any questions on Schedule B1? Again, anything that's a problem for your title will be showing up on Schedule B1. Next, we'll go to Schedule B, Section 2. Exceptions 1 through 5 are pretty much normally removed at closing with an affidavit of title. Number 4 is removed if a survey is obtained. If it's not, we remain that exception. A lot of times, there's times when the buyer doesn't want to get a survey, but the lender will take what's called a no survey endorsement. So then we can remove it as to the lender because they require that exception to be removed. But if the buyer doesn't get it, then get a survey, then, like we said before, he's kind of on his own if there's ever any issues with encroachments or any other kind of survey issues. Number 6, this exception usually remains, well, always remains, because it tells you the status of the taxes, the water, sewer, anyway, anything that's on here. We will have to get updates up through the date of closing to make sure everything's current. And so that exception will say, the taxes are paid through third quarter, water, sewer has been paid through whatever. So that's always taken care of, so the buyer is covered up until the date of closing. Again, after that time, they're responsible for any kind of charges that happen. Number 7, this is in case there's been new construction or if there's been any kind of improvements done to the property. It'll show up on the tax search, because what happens is if there's been work done on a property, it takes almost a year for it to get charged into the assessed value of the house. Just the tax department, it takes them a while to catch up. So we've had in the past before where somebody's had a huge addition done on their house, and then the taxes will change, come next March or something, and they say, well, how come my taxes went up so much? So we'll see this on the tax search. It'll show that there's been an application for a permit or something, so they're aware. So then again, we'll remain that exception, just so they're aware that their taxes are going to go up because of the major improvements that have been made. Number 8, this has to do with things that are under the surface of the ground, that, like oil tanks or possibly septic tanks, anything that's not visible to the naked eye. A lot of times surveyors won't certify that they've done any kind of search on the land that tell you that. So we put this on to the owners because if there is a tank that wasn't disclosed, it's going to be a problem for the new buyer down the road. So, and that's something that we don't really get involved with because it's considered environmental or a governmental thing. So that's another thing that's needs to be disclosed by the seller. And like I said, it can be an issue if it's not. Number 9 is for bulk sales. That's usually for properties that are rented. They have to go to the state and I guess make sure that they paid their taxes and they're registered. So again, usually it gets more involved with that on rental properties or commercial. The buyer's attorney has to contact the state with an application and they'll come back and say there's no monies due. But again, we remain that to the owner just in case they haven't gotten the bulk sales letter from the state. If they give us one, then we remove it. If
When
not,
you say remain that to the new owner, like
Yeah.
what does that mean to the new owner? Like,
well, it means that he's going to be subject to that if there's any issues down the road. That would mean that he or his attorney did not apply for a bulk sales letter that would say there's no
so
money
they
due.
take ownership of it.
Yeah. So that's why it's important to make sure that the seller discloses if there's possibly any bulk sales issues involved with the
So
sale.
any property that's a rental property, and someone invests in that's a rental property, they have to get a bulk sales?
Right, bulk
Okay.
sales clearance letter from the state. I guess they just want to make sure you're paying taxes on your income that you're making from it. So this way they kind of double check themselves to make sure that they're getting what they deserve, the state.
Can the seller request that themselves?
It's usually, for some reason, it's up to the buyer to do it. Usually the buyer's attorney does it. I don't know why it's set up that way.
Well, down here, we don't necessarily have a buyer's attorney
Mhm.
in a lot of the
Yeah,
transactions.
it's on the buyer. It's the buyer's responsibility to do it.
So he's checking if the seller has paid the taxes on it?
Yeah, if there's any monies due.
Doesn't that follow the buyer if he doesn't get a clearance letter? Isn't that why
Well, they
the
would have to go
buyers
after.
generally generate that request?
Yeah, I mean, the seller has to cooperate and work with them and give them the information needed. I mean, the buyer can't just send up a letter without giving some pertinent information that'll disclose who the seller is and that kind of thing. And then at that point, the state can give the clearance letter. Yes?
I had that happen a couple of times. Called 5 different attorneys. All the attorneys say you don't need it.
Really?
Yeah, I'm just letting you know. I mean, I've gone through it. And we've all sold properties here that were rented at one time or another. And there is a rental history with Margate, whatever. The
Yeah.
attorneys are saying you don't need it. Now, I had a seller's attorney insist that my buyer applied for that. And at that time I did. And then I had another sale very similar in the same complex. So I said, let me call my attorney and see what he says.
Yeah. Well, again, we're accepting this on the policy unless we get a clearance letter, so it's really gonna be on the buyer if there's ever an issue.
Right.
So.
Or they get an indemnification.
Yeah, exactly. Okay, so continuing on, it's exceptions 10 through 12. These are different things that we pick up in the county that are such as, number 10 is a filed plan. If there's setback lines, they're going to remain. If there's any conditions shown on the filed plan, that's where we will show as an exception. Sometimes there's like a site easement, if it's on a corner, if there's driveway easements and different things that all show up on a filed map, and we make exception to that. That will remain on the policy as an exception because there's nothing you can do to get rid of that. The same with number 11, it's an electric company and New Jersey Bell Telephone Company easement. Gives them the right to come on your property to service the electric or the telephone. And so again, that remains as an exception because everybody wants electricity or telephone lines. Number 12, this development has a declaration of covenants and restrictions, which sometimes can be 2 or 3 pages or 50 pages depending on the development and how in depth they want to be. Usually when there's a declaration as this, there is an association, which means that there's fees owed and there's different things you have to do if you want to change the color of your paint on your house or bushes, trees, that kind of thing. You really have to read through this because that can really dictate what you can do with your property. And if there's any other kind of easements or restrictions, this is where they'll show up from exception 10 on. I mean, we've had some properties where there's like 20 exceptions. There's all kinds of like riparian grants, other kind of easements to different like neighbors, like access easements, and especially on commercial property, there can be a lot of exceptions, but this is where they would all show up. The bottom part here is if the lender requires any kind of endorsements. These are the ones that are offered. Pretty much it's the lender just really wants the restrictions and encroachments and the environmental. That's the main ones they want, but sometimes, they're picky and if it's a condominium, they'll want that one, or a planned unit development. So it really depends on the lender or what's applicable to the property. Again, and if there's a survey endorsement, that is something that we get involved with too. So that's pretty much just a basic overall look at the title commitment. Does anybody have any questions or comments?
So you can see on the title commitment, there's a lot of items that Don and his team need to review to put that together. And basically, the title insurance commitment is saying, Atlantic Shore Title is agreeing, committing to insuring this title, this particular property listed on the title commitment, this legal description, from this seller, who we find is the record owner, to your buyer. And the following things must be taken care of before we can do that. We must clear these items so that the buyer has clear title to the property. And that's what Don went over in section 1. We have to clear everything in section 1 before the buyer can take title without any of the seller's liens or issues or problems. And then part 2 is saying, and these items go along with the title to the property, which are certain items that go along, easements and restrictions and so forth that go along with the property. And that's kind of the picture. So we're committing to do that as long as all these items are met, and at the closing, the actual transfer of title takes place. And usually, on a cash transaction, the title company is issuing one title policy. It's called an owner's title insurance policy, and it insures the purchaser, that they have free and clear title to the property. And if they don't, then they place a claim with the title company. When a buyer obtains a mortgage, we issue 2 policies, because the mortgage company lending the money, they want their own title policy. If there's any big title issue that happens or some forfeiture of title, the mortgage company wants to know they're insured for the amount of money that they have lent to that buyer. So we're issuing 2, and that's why we must comply with all the lender's requirements. So it's important that we do know as early as you know who the lender is, so that we can begin to work with them, meet all their requirements, because they're all a little bit different. They all want different language and different endorsements. So John and his team works with the mortgage company in the process to make sure that they have everything they have, because they want to be protected for what their investment is in this property as well. And then once that part is done, it moves over to Deb Steinling and her team in the closing end of the business.
Let me back up a notch. Title insurance is the purpose of protecting the buyer, and obviously now we just found out the mortgage company, from any problems that come up down the road to the legal ownership of that property.
Yes, or encumbrances or liens, maybe unpaid liens.
What happens if something comes up?
So if something does come up, then that buyer can put the title company on notice. You know, Miss Buyer went out to get a home equity line, and my home equity company is saying there's a mortgage on there from the prior owner. They notify the title company, and then the title company has to research that. It may be we did pay that off at closing, but that mortgage company didn't file the paperwork at the county to take the lien off record. It could be we missed it. If we missed it, we're on the hook. And we'd have to go after that seller.
And the duration of the title insurance is for the complete ownership of that property
Yes,
until
it
you
is.
sell it?
So unlike other insurance, it's a wacky kind of insurance, because unlike other insurance, homeowners insurance, auto insurance, you're paying for a future event. So you pay your premium every year, and it's covering you for what may happen in the future. Title insurance is in reverse. It pays you for you're paying for the past, what may have happened in the past. You pay it once, and it's good for the life of your ownership of that property. The loan policy is good for the life of that loan. You know, when you pay off that mortgage, that loan policy dies, you may purchase a property and pay for your owner's policy and pay for your mortgage policy. If you go to refinance with a different lender, that lender's gonna want their own title policy. So we do closings on sales, but we also do closings when people refinance their properties, and then we deal with just the owner of the property and the lender.
I have a question about the riparian lease. Does the seller have, or not the seller, the buyer, do they have to apply for that, or does it automatically transfer over when the house is
You wanna
sold?
talk a little bit
Yeah.
about that?
The riparian lease is area that's out in the water, so it's not something that's insured, because we only insure the land, or if there's a riparian grant that goes out into the water, but a license is a yearly fee that you have to pay to maintain it. So if there's been a current license on the property, they have to file the paperwork with the state and have that license assigned to them. And it's something they do with the New Jersey Department of Title. Yeah.
Has everyone heard of that, Tidelands and Riparian?
Yeah.
Okay. All right, I mean, we don't run into it all that often these days. I mean, it kind of went into effect, what, 1981?
Yeah, well, the Tidelands claims.
The Tidelands claims went in 1981. So most properties have been sold since then, but we still do. You may get an elderly couple who has owned this property since the 1950s or 60s or 70s, and they go to sell, and we find out that a part or a portion of their land has been claimed by the state of New Jersey. And because what the state did, I'll let Don comment on this further because he's the expert in this, but the state, when they passed that law, it went retroactive. And they used maps that were hundreds of years old for creeks and waterways that had long dried up and gone away. But they made it retroactive and went back and claimed that property. The title industry to this day still does not know how that law was passed. We must have really lousy lobbyists. But what it did was title companies had massive losses in the 1980s along the shore area because we were paying claims on every property that was sold because the state made it retroactive. But they still pop up. And issues related to that still pop up.
Yeah, and it's really based on the land value, not the whole value of the house on the property, it's the land value is what the state goes by when they are trying to settle the claim.
Yeah, I just have a house I'm gonna list and then they have a recurring lease. So I just thought I'd try to get a jump on it if I had to do something
Yeah.
professional.
Yeah, I mean, you can contact them, usually the seller probably has like a license number.
Yeah.
And you can actually get the paperwork, and what they want you to do though is wait till the deed's recorded, and then you have to send that up with a package. I mean, it tells you what you need when they give you the application, but they want to see it, the new buyer actually owns the property.
Okay, so
Yeah.
it's after, okay.
And once you get the recorded deed, you can actually go ahead and do that.
Okay, thanks.
Okay, thanks, Don. All right, Deb Steinman.
Watch that drawer, it doesn't close.
Does it?
That'd be a tough beginning.
Hi, I'm Debbie Steinway, I'm the manager of Atlantic Shore. We just wanted to touch base first before I go over the settlement sheet and the Alta. We had also put a form in the packet, which gives us a lot of information we really, really need. Kathy had mentioned putting it in your computer.
Yeah, we'll put it in W,
Okay.
in the KW library.
Perfect, so it'll be right in there.
It's not.
If you can really take just a few minutes to fill it out, it will definitely make our jobs easier along with yours, because it's going to make the transition go a lot smoother, the transaction. We need the email addresses of the buyers, the sellers, their cell phone, home phone number. If the buyer or seller have an attorney, that would be nice, we really need to know that. Along with, as Christine and Don had mentioned, the mortgagee information. You have, when you first get the contract, we know you don't get that. But as soon as you find out who the lender is, passing that on to us will be really greatly appreciated. And then on the bottom of the form, we ask for, if you would like us to order a termite, a survey. That would also help in the beginning, and if there's somebody in particular that you want to use, you can fill that out. If you are okay with anyone, we will find someone for you. And also, under the seller information, the listing agent. A lot of times in the contract, it has the company, but there's no actual agent listed, so it would help us so we can contact them. The more information we have in the beginning, the smoother it will go. You guys have any questions about that, or?